We ready?
Yes.
All right. Like you said, my name is Judson Crump. I'm a consumer rights lawyer. I'm one of about 5 of them in the whole state. I'm not joking. That's true. There aren't but a few people that do what I do. Y'all might know Underwood and Reamer down here. They do a lot of mortgage foreclosures, things like that. So looking at my handout, I've got a little bit of introduction about what consumer rights law is, and it's basically broadly the rights that individuals have against businesses that do them wrong somehow. Okay, you know, if you bought something that was falsely advertised, okay, or if you have a product that's not in compliance with its warranties, okay, or if you've been defrauded somehow, old-fashioned fraud. There's also some newer statutory consumer law. I say new, meaning not common law, old school stuff like the Fair Credit Reporting Act, the Truth in Lending Act, the Fair Debt Collection Practices Act, all those federal consumer protection statutes from the 60s and 70s that you might not know how to use them or when they really apply. I deal with all those too, okay? Now some of y'all, if you work for older lawyers, they might think of consumer law differently than someone from my generation would, because when in the 70s and 80s and 90s, you could really make a lot of money doing consumer rights law. I mean, there were, a lot of cases nowadays go to arbitration that wouldn't otherwise have back then. You could have class actions in the old days over fraud and things like that. Those things just don't exist anymore because our case law now allows companies to basically fine print their way out of a lot of stuff that they otherwise wouldn't have been able to get away with in the old days. So, it used to be that you could get $1 million punitive damages verdict against a car dealer, for just lying to someone about whether a car had been wrecked or not. You can't do that kind of stuff anymore, okay? But, some of us still somehow make a living doing it, okay? Someone talk to you about what that means. Probably the biggest area for phone calls I get and cases probably involves the car industry, okay? There's a lot of fraud at car dealerships, particularly used car dealerships. And as I said before, what you can do about it is much more limited than it used to be. But those come in basically 2 types of cases. One is cases involving the condition of the vehicle, which would be things like, they promised you it was never wrecked, or they showed you a fake Carfax, or something like that, where you basically sell you a piece of junk and it's not what they represented it to be, okay? Those are what you'd be a common law fraud case, all right? The other category of cases mostly involve the financing, okay, where they have maybe somehow broken one of the consumer protection statutes like Equal Credit Opportunity Act or Truth in Lending or something like that, all right? A few examples, you see, there's a thing called Yoyo Sales, all right? That is where a car dealer takes someone's credit application, makes a deal to sell them a car. They say they've been approved by a finance company, and they drive off the lot with the car when in fact they've not been approved, okay? Or they've maybe been conditionally approved, and then a few days later, or maybe a few weeks later even, they'll call the buyer back and say, hey, your financing fell through. We need you to come back and sign more paperwork, or bring a cosigner, or more money for a down payment, okay? And a lot of times it's just a scheme to steal their down payment, basically. Maybe the financing really did fall through, or maybe they're making up an excuse, okay? A lot of times it's the dealer's fault. In any event, you shouldn't be telling people they're approved when you know, in fact, that they're not actually approved, okay? That's fraud, and that can also violate the Equal Credit Opportunity Act and the Truth in Lending Act, depending on how the dealer structures the deal in the paperwork and what they do in terms of providing written notice of whether or not they've been approved or denied, okay? Those are very common, and a lot of times they end up in repos, all right? I do a lot of repo cases, wrongful repos, and repos that might have been right when they happened but were carried out improperly, or maybe handled improperly after they were done. When you repo someone's car, you don't just get to keep the car and keep the money. You've got to account for what you've done with it. All right, if you owe me 10 grand on a car and I take it and I sell it for 15, I don't just get bonus money of 5 grand because I happen to repo a car that you had equity in. You got to account for that surplus. But a lot of times they don't even do that, particularly in a yo-yo deal. all right, or a buy here, pay here dealership. All right, I've had cases where it's a buy here, pay here deal. They repo the car, and then rather than put it through an auction or have some process where they can account for how much money they got for the car and what they spent on repo fees and reconditioning and whatnot, they just put it right back on the lot and then sell it. And the next thing you know, someone else is driving this car, and you look at the title history, which you can get for $15 from the state, and it turns out that they sold the car 2 months after they sold it to my client for $1,000 more than what was owed on it. And when you do that, they're not only liable to the consumer for the $1,000 bonus money they stole, but there's also a statutory penalty where they have to refund all finance charges in the contract. If you know how buy here, pay here dealers work, the interest rates on those car notes are like 28%, pretty ridiculous. Sometimes more interest than there is price of the car. So you can make them cough up that money, and so those can be pretty good cases because they don't require a whole lot of proof. It's a math problem, all right? So, if you ever get a repo case that sounds fishy, feel free to give me a call, because if it smells fishy, it's probably illegal somehow.
If you get one of those successfully completed, do you get damages?
Yeah.
Or just a flat dollar for dollar?
Well, the statutory penalty is a minimum penalty. Okay, so if you can prove actual damages above the statutory penalty, and let's say it's a $10,000 car with $8,000 of interest, okay, you actually get the $8,000 of interest plus 10% of the cash price, which would be 10% of $10,000, which would be $1,000. So the statutory penalty would be $9,000. Now, if you've had more damages than that, then you can get infinite, whatever your damages are. And repo damages can also occur to other people besides the debtor. If your friend is parked at your house for a Christmas party and the repo man comes and yanks the car and knocks down your trees and bushes and all that, that's illegal. They can't do that, okay? There's a lot of things that are illegal that repo men do that they either don't know is illegal or just don't care, because most of the people that they're dealing with are broke, can't afford a lawyer, aren't really educated enough to know they have any kind of rights, and so they're used to kind of getting away with whatever. There's lots of rules repo men can't break. They can't touch you. If you're in the car, they can't move it. That happens sometimes. People get in the car and the repo man tows them anyway. I mean, they can't lock you in it. They can't box you in on the highway. That happens. I mean, all kind of stuff happens. I had a case a while back where the guy had his car parked in his carport, and his ex-wife, or I guess soon-to-be ex-wife, he knew she wasn't going to pay the note on it. It was her truck, right? And so he thought she was going to come and take it, and his lawyer had instructed him, his divorce lawyer, to chain it up. So he had it chained to his carport. Well, the repo man comes along and just doesn't bother to check that it's chained up and yanks his whole carport down. Yeah, which is illegal and causes lots of damages. You can't destroy someone's house to repo a car, okay? They can't even cut a lock, okay? They can't even go through it, get in your garage, okay? They can't open a locked gate, all right? So none of that stuff, all right? If they do that, give me a call, because the same statutory penalties apply. It's called a breach of the peace repo, all right? A few other things car dealers do. Title fraud. They'll sell you cars that they don't actually own. I had one of those before, where it's the dealer's personal vehicle, and he owes Family Security Credit Union a bunch of money on it, and he sells it anyway and just keeps taking payments and then doesn't process the paperwork, and for like 6 months, just hoping to float, I guess, hoping the buyer won't notice that they ain't got a tag for 6 months. I mean, that stuff happens, okay? Salvage fraud. Any car that's been previously wrecked and has a certain amount of damage has to be disclosed as a salvage vehicle. They got to put what's called a title brand on the title, all right? A lot of times they won't do that. They'll represent it as just a regular used car when in fact it's been wrecked before, all right? To a degree that it's got to be called a salvage vehicle.
Is that the same for flooded vehicles?
No, flooded vehicles is different. There's not really a statute on flooded vehicles. There was some kind of regulation when Katrina came out. There was a flood of flooded vehicles on the market from Louisiana, And they had some rules about that, but those cars don't really exist anymore because they're just all dead now. But with all these hurricanes down in Florida and in Texas, that's going to be something you're going to watch out for, because on those cases you'd be looking more at common law fraud. Okay, I think that might be picked up on the Carfax. It should be, at least. Different states. Another thing that's weird about cars is that different states have different rules when it comes to how you got to disclose things like flood damage or salvage history, and what might be something that would create a title issue in Florida doesn't matter here in Alabama. So you can sometimes take a car from one state and sell it in another one, depending on who has the looser disclosure requirements. Okay. So the best kind of cases in fraud are where someone is actually asking the right questions. The buyer's saying, "Has this car been wrecked? Has it been flooded?" Where they're getting affirmative answers, to yes or no questions. Because if you want to make a fraud case, you got to prove they lied about something that you can prove is false, and it's not a statement of opinion. This is something like, "Oh, it's a great vehicle. It's in top-notch condition. I love this car. It's my favorite car on the lot. It's got great mileage." Those are all opinion statements, and you can't do nothing about it, even if it's a total piece of junk and they know it. Or if they lie to you about something to your face, but in the paperwork it's true, you're stuck. All right. If they have the truth in the paperwork and it's clear, this vehicle's been wrecked before, well, you're not going to be able to do anything about it. All right. Now, let's see. Okay, another thing. Financing fraud. There's a few types of that. Well, there's not a few. There's a million types of financing fraud. A few common ones, like I said, lying to someone about whether or not they've been approved. Okay, that's one. Another big one is if you've got a credit application, you're required by law to give someone a written notice of your decision within 30 days. Okay? Meaning if you don't approve them on the terms they ask for, you've got to give them a written statement of reasons why you didn't approve them. And it's got to be in writing. It's got to be done within 30 days. That's under a law called the Equal Credit Opportunity Act. It's from the 70s. It's designed to prevent discrimination, but it's also informatory. So they break that one a lot, because maybe they'll deny you and just sort of forget about you. All right? And if that messes you up, if that causes you harm in some way, like in a Yoyo sale, where you're driving this car that you paid $2,000 for, and you're waiting for your payment coupon book from the bank, that can cause people significant harm, particularly if it involves a repo that happens after that. Okay. Another thing they might do is messing with your credit reports. Okay. Maybe they've pulled a cosigner's credit report without their permission. You go there shopping with just your mom or your husband or someone, and you apply for credit, and somehow they get someone else's information that's related to you, and they pull their credit report. Well, you can't do that. It's called an impermissible inquiry. Those are illegal under the Fair Credit Reporting Act. They are not allowed to submit false information to their own finance companies. I've had that happen sometimes, where they make fake pay stubs to get a deal approved by a finance company for a buyer that's just got horrible credit and like 2 repos on their record or something, and is working minimum wage. They'll make a fake job for them, a fake second job, and make a pay stub and send it to them. Obviously, that's illegal. It seems like it's obvious, but this stuff really happens. Okay, so that's something to watch out for. Warranties, pretty obvious when you have a warranty case. If you have a major defect on a vehicle, or really any product, technically any product over $15 is subject to the Magnuson-Moss Warranty Act, which means that if the product doesn't conform to its written warranty or the regular old implied warranties that are implied by law, which means the warranty of merchantability, you know what that is? It's basically common law warranty. When you buy something, it's implied by law that it's going to work the way it's supposed to work. When I buy an iPhone 6, it's going to make calls. It's going to let me look at the internet, when I have service. And the good thing about that is that for any product over $15 of purchase price, it's fee shifting. So, this little camera phone here, if I had to get in a lawsuit with, was that Apple? I guess Apple, over the warranty, and I won, they got to pay your lawyer fees, okay? And it's supposed to be based on your hourly rate, all right? Even if it's only only $800 phone, I mean, you can bill them for $8,000 if you have to, depending on whether or not the judge thinks that's reasonable, all right? So warranty cases are kind of difficult though, because you do need an expert usually. You're gonna need a mechanic or someone who's competent to testify that, this thing's broken. It's not the way it's supposed to fix, and it came that way, all right? The buyer didn't, slash his own tire or go mud riding and wear out his transmission, things like that. But with warranty cases, if you've got a clear defect and they've been given an ample opportunity to fix it and it still isn't working yet, that's a warranty case, all right? You can sue in state or federal court. And like I said, it's fee shifting. In warranty cases, you basically are limited to actual damages though. So it's going to be the cost of the product itself usually. Very rarely, but possibly, you can get what's called consequential damages, like lost work, things like that, okay? But sometimes warranty cases can be big, like an 18-wheeler. I got a client who's got an 18-wheeler that's been in the shop 20 times. 18-wheelers are very expensive vehicles, all right? So, the contract price of that thing's like $180,000. That's a big case, all right? Yeah, and it's his livelihood, all right? So, sometimes warranty cases are worth doing, all right? But I guess to take away from that, even if you have to get your boss to sue somebody in small claims court for a busted iPhone, he can get paid, if he asks the judge to do that. That's possible. So usually warranty cases involve new cars though. All right, used cars don't come with a warranty in Alabama, or at least an implied warranty. They're basically just as-is deals if it's used. So it's caveat emptor with used cars. New cars all come with warranties, and there's also the lemon law. The lemon law is rarely useful because it's limited to the first year you're in the vehicle. All right. Almost always in a lemon law case, people call you and say, "Hey, I got a lemon law case." What they really mean is they have a warranty case, because warranties just last longer and have less hoops to jump through. All right. If you, for instance, if you want to make a lemon law case, you got to not only give them 3 chances to repair it, but you've also got to, after the 3rd repair chance, you got to write them a certified letter at their manufacturing address to tell them, "Hey, come fix this thing," and give them yet another bite at the apple, which you might not want to do if it's like your steering's out. You don't want to give another chance because it's unreasonably dangerous to be driving that car on the interstate if the steering might go out on you. So if you hear someone say they have a lemon law case, that's fine. They can call it that, but they mean it's a warranty case. All right. I want to talk about identity theft. This is actually really common, as y'all are probably aware. And what can you do about it? The most common cases I get with identity theft are cases where they end up being credit report cases. And I love credit report cases because your defendants always have deep pockets and you have multiple defendants, okay? If someone, just to take my most recent credit report case as an example, some identity thief based in Atlanta convinced Experian that the Atlanta address this person created was my client's real address, and got a credit card shipped to that address, okay, from Chase Bank. And they spent about $14,000. My clients had very good credit. So they got a $15,000 credit card and spent about $14,000 on gold sunglasses and engine parts, things they could move and liquidate easily, all right? And my client sent a written dispute letter to the credit bureaus when she found out about this, which didn't happen until her existing credit card with Regions got canceled. They said, "Hey, your debt to income or your debt to income ratio, your utilization ratio, I don't know if you know what that is, the amount of credit you have versus the amount of credit you use. It's one of the factors that goes into your credit score. Or utilization ratio had gotten jacked up by this sudden $14,000 unpaid debt. So it ruined her credit, got her credit card canceled, which she actually couldn't really do anything about. Under the credit card, under the Fair Credit Reporting Act, you don't really have any right to fix anything until you've disputed the item with the credit reporting agency. So if you ever have any client or a friend or yourself or anything that has a credit report issue, the first thing you need to think of is write a written dispute letter. Because until you do that, you basically have no rights at all. Technically, under the statute, you can sue the credit bureaus for false reporting, but only if you can prove that they don't have reasonable procedures designed to ensure maximum accuracy. Well, credit bureaus are very, very large, rich companies, and they have professional witnesses whose only job is flying around the country telling juries how great their procedures are. You know, you're not going to win on one of those cases. I don't even bring them. All right, you always dispute. All right. So identity theft, though, it's illegal for the thief to do it, but the thief you're rarely going to catch the thief on your own, or find a thief that has anything to take. All right, I've had one of those, where the manager at Advance America Title Pawn was writing fake title tickets in my client's name, and well, that's great, you know, because it was the manager. Boom, Advance America's on the hook. I got that. Do you have a question? Okay. So that was nice, but usually there's a thief that's just somewhere like in Russia, some kid in Russia or in Atlanta or wherever who's doing this stuff. But the good thing is, though, you can't be held liable for that debt. All right, under a law called the Fair Credit Billing Act, you can't be charged for more than $50 of unauthorized charges if you let them know within 60 days of getting your statement that shows the unauthorized charges. Now, if it's a real good identity thief and they don't send you the statement to your actual address, that clock doesn't start ticking, all right, till you actually find out about it. And so, as kind of common sense would tell you, you're not on the hook for that money. All right, if Chase goes after you for that money, you have a defense to it. I didn't authorize the charges. Okay. Particularly if they sue you for the money, there's a special provision in the Truth in Lending Act that says, you know, they got to prove each charge was actually authorized. All right. Now, if it's not authorized, they can't prove that, and you just go to court and tell them, and then you win. You know, that's unpleasant to get sued, but you have a defense. But when you do have someone who's been identity thefted and they find out about it, the first thing they do is they write a letter to all the credit bureaus telling them, hey, I've been the victim of identity theft. They provide a copy of your driver's license to prove who you are and where your address is. And they've got to fix it within 30 days. All right. If they don't, then they're liable for any damages that causes you. That includes credit damage, lost credit, emotional distress, things like that. All right. And not only is the credit bureau liable, but also the creditor who reported the information. So the $14,000 Chase Bank example I talked about earlier, Chase is on the hook, as well as TransUnion and Experian and Equifax, if they refuse to fix it, which in my client's case they did. Because the way they do disputes is it's very automated. You send a dispute, you might send a perfectly written letter with a copy of your driver's license to prove who you are and what your address is. You might send all kind of evidence showing clearly this is not my debt. But what they're going to do is when they get that, they're going to turn that into like an 8-line computer code that's going to get emailed to a kid in India who processes about 20 of these things an hour, and then they're just going to send an email to Chase Bank, who will then say, yeah, we looked at the records, it looks right, leave it as it is. Okay? Very, very little human intervention is involved in processing a credit report dispute. It's something that surprises people because it kind of defies common sense. It's not the way ordinary humans work, but that's how it is. And so errors are very common, even when you can prove that it's an error. So, those are also good cases, like I said, because the defendants have money. They like for them to go away once you can make it clear that it's not, that they're wrong. They'll pay you to go away, and you got 3 of them, and there's no right of contribution either. So if I get 20 grand from Equifax, TransUnion doesn't get the benefit of that money. You basically stack them up, all right? And it's fee shifting. So they got to pay your lawyer if you win, all right? Alabama's identity theft statute, we do have one. It's actually part of the criminal code, but it's got a civil right of action. It's got a great 7-year statute of limitations, and it's got a $5,000 per act of theft penalty. Fantastic if you can find somebody who's liable that has money, all right? That's rare, but it does happen sometimes. What, 25 minutes? All right, that's a lot. Let's see. Okay, I figured. I want to do a little bit about arbitration. Some of y'all, y'all have to know what arbitration is. I assume most of y'all do. A lot of good cases go to arbitration. Now, people in my position, consumer rights lawyers on the plaintiff side, we complain about arbitration because of how unfair it can be, mostly because it has class action bans that basically prevent you from being able to go to a class, which in a small dollar case just makes you have no case at all. It's a get out of jail free card. I hate that. And you have no appeal. So if you have a terrible arbitrator and he does a terrible decision, despite him, the defendant being on tape recorder, admitting he broke the law, you can't do anything about it. Like nothing, all right? I hate having no appeal. It makes my head want to explode, all right? I'm sure your bosses feel the same way. But it's not, as some people think it is, a sort of an automatic win for the defense, okay? You can get a good arbitrator. You can win even with a old, crotchety corporate lawyer being your arbitrator. I've done it before. It happens. You got to show some bad acting on the other side, but that's not often that hard to do. Okay, Chuck Stevens, for instance. I had a, I can't go into that, but he came off the wrong way to an arbitrator who should have been, looking on his case from a defense lawyer arbitrator, and I won, right? That's just what happens. Because he couldn't quit talking. He just couldn't quit talking. And he kept digging a hole, and, that was great. But, let's see. But the one thing you might want to know about arbitration is it's very expensive for the defense. If I have an arbitration clause and I have a case that might be worth $10,000, okay, they've got to pay about $3,000 to arbitrate the case. Okay, most of them refer to either the JAMS or the AAA rules. In any event, they got to fork out about $3,000 to pay arbitrators' fees and administrative fees and all this stuff. That's if they win or lose, they got to pay that. Okay, and arbitration can be good for some cases. It can be good. Some cases you don't need a jury on, like a statutory damages case, like a robo phone call case where you have an automatic penalty of $1,000 or $1,500 per illegal phone call for telemarketing calls. That's great to have an arbitrator because they understand the law and they have a calculator. It's a math problem. You don't need a jury for that. So I guess arbitration is, as it exists now, the law is unfair in some ways, but it's still not a case killer. Okay, I'm not afraid to go and arbitrate if I have a case that I'm going to win anyway. And so that's one thing to kind of remember. A lot of older lawyers I encounter who remember the good old days of fraud cases, they think of arbitration, they're like, arbitration clause, it's lost. That's not true. So, don't write something off just because, you've got an arbitration clause. That's about all I got. I wrote down some of the random selection of consumer credit laws. If you have any questions, I'll be happy to answer them now.
Is there a time period that you could file against a repossession?
Repo? Yes. It depends what kind of claim you're making. All right.
I'll give you a scenario.
Give me a scenario. Go ahead. Trespass and conversion is 2 years. Fraud is 2 years. Breach of contract is 6. No, 4. Bridge contract is 4 actually. You might need to know that. A contract for the sale of goods doesn't have the normal 6-year statute of limitations. It's got a 4-year statute. A lot of people don't know that, but what's the scenario?
This guy bought a car from a pay here, buy here car, and he made a large down payment on the car, was making his payments on it and everything. And all of a sudden he gets up, they go get a tag for it and everything. He gets up one morning, the car is gone. Don't know what happens to it. Called to see if it was stolen. They reported it stolen. He called to see if it had been repossessed and all this. Nothing. The guy who bought it from me kept trying to call him, couldn't get him to return his call, do anything. Well, they find the car sitting at a credit union. So they go and inquire about it, and it had been brought to the credit union. The guy that he bought it from had a loan at the credit union and was not taking the money that he was paying him and applying it toward the note on the car. So the credit union picked it up.
And you want to sue the credit union, or you want to sue the?
Well, I don't know.
Well, if you could make it, you'd be 4 years. 4 years to bring it against the dealer. Yeah.
This was a client that came in and saw us, and so I may see about sending him to
Sure. Yeah. He would have 4 years to sue the dealer under the contract, because most contracts say, if you pay, we won't repo the vehicle, basically.
Well, it's like you said, that, I don't know if the guy got it back or that he hadn't auctioned it or done anything. He probably come around and
He probably
resell it
did.
again.
Yeah, he probably did. Okay. That would be 4 years for bridge contract. It'd be better if you could bring it in 2, because then you could add a conversion claim, which carries punitive damages.
It hadn't been probably a month ago, so maybe 2
Oh, yeah.
months at the top.
Yeah, well, he's solid. Yeah. All right.
What about, or what do you think about companies like LifeLock that are supposed to help protect you? Or,
I've never dealt with them. I've never had any complaints about them. One thing I have encountered is debt settlement companies and credit repair companies. They're pretty much all horrible.
yeah.
Just don't sign up with them. They're like all scams, particularly debt settlement companies, because they don't do anything you can't do. LifeLock, though, I don't really know how they work.
Not sure either. It costs you money to sign up for it. I know that.
Yeah.
And they say they protect you up to $1 million if your identity's stolen.
Yeah.
But I'm going, well, okay.
I don't know. I don't know about LifeLock.
And I know there's other ones, but
That's the big
one I see the commercial.
Yeah, because they got the guy with his social security number on the 18-wheeler riding around town.
I'm protected, yeah.
Yeah. Yeah.
So,
All right.
I had signed up for it. Oh, okay.
Okay.
Yeah, I'm done.
Was that? Yeah. Okay. Sure. Let me get this thing off.